and Sarah. And welcome everybody. And today I wanted to share that we're covering federal FMLA and not necessarily including state laws that sometimes provide additional protections. So what we're going to cover in today's agenda is the federal FMLA and ADA overview and overlap, how to recognize leave requests, assessing and responding to leave requests, administering FMLA and ADA leave, and when an employee is ready to return to work. So with that, I will turn it over to Fran to take it away. Thank you.
Thank you, Cindy. And everyone, you'll have to bear with me. I've come down with a bit of a cold. I was going to call Cindy and say, hey, I need to take a leave of absence today for the call. But the common cold, is neither a disability under the ADA nor a serious medical condition or FMLA. So I am here replete with tea and cough drops, and so I should be good. And it's a very fun and interesting topic, so I'm so excited to talk about it. We're going to start with section 1, what the FMLA and ADA provide in terms of protections and how they intersect. So here you'll see on this slide, we've synthesized kind of the 4 key elements of FMLA and ADA, starting with employer coverage. FMLA is going to cover private employers with at least 50 employees. It covers all federal and state agencies. It covers all public and private schools. If you're an agency or a school, doesn't matter how many employees you have, you're covered. ADA is going to cover employers with at least 15 employees, much lower threshold. Federal agencies are not subject to the ADA. They're subject to the Rehabilitation Act, basically the same requirements there. Eligibility. FMLA requires 12 months of employment, does not have to be consecutive. An employee can go back 7 years to tally up 12 months of employment with the same employer. And an employee needs to have at least 1,250 hours of service in the 12-month period immediately preceding the leave. The ADA, no eligibility requirements like that. Applicants. We're talking about leave today predominantly, but you should know applicants are entitled to accommodations during the interview process under the ADA. Employees, they're eligible on their first day of employment, so a much broader protection. Entitlement, what do you get if you're covered? Under FMLA, 12 weeks of unpaid job protected leave in a 12-month period. There's a separate provision that allows for 26 weeks for military service member leave. We're not talking about that today, but you should be aware of it. Under ADA, there really is no definitive entitlement. An employee is entitled to leave as a reasonable accommodation unless it would constitute an undue hardship. Now, what's reasonable is going to depend on the facts of a case. Courts will generally say reasonableness means it's reasonable in the run of cases, or it's feasible in most cases. Undue hardship means it's a significant burden or expense on the employer's entire operation. That's a key. And the purpose. I think it's very important to understand the purposes of the 2 laws, because we talk about them together a lot, like we're doing today, but they're different laws with different purposes. Congress was motivated by different things when it passed these laws. FMLA, Congress's goal was to balance work and family life and give families economic security. If you need time off of work, you can take it and your job will be here waiting for you. ADA had a different purpose: remove workplace barriers for individuals with disabilities. The idea isn't taking time out of work, it's getting people into work. So keep that in mind as we go through the presentation today. So here we've covered the reasons for leave under both statutes. And FMLA, there are several. We're only really focusing on the top 2. Employees' own serious health condition or to care for a family member with a serious health condition. ADA, So ADA ADA leave is available where an employee has a physical or mental impairment that substantially limits one or more major life activities, that is a disability under the ADA. And the leave would permit the individual to return to work after time off because of the disability. And the leave would not constitute an undue hardship. So one thing jumps off the slide to me, and that is FMLA, if I have a serious health condition, I can take leave. ADA, if I have a disability, maybe I can take leave. FMLA, if my family member has a serious health condition, I can take leave. ADA, there's no protection for family members with disabilities or medical issues. The ADA does not require an employer to accommodate an employee's relative or family member who may have a disability. That is a key distinction from the FMLA. But one thing to keep in mind, just because the ADA doesn't require leave for an employee's family member with a medical issue, there's a concept called associational discrimination. Associational discrimination is prohibited under the ADA. It occurs when an employer takes adverse action against an employee because of their relationship with an individual with a disability. So you might be thinking, how does this apply to leave? Well, here's a very common scenario. An employee goes to their supervisor. Let's say Cindy. Cindy goes to our supervisor and says, I need time off from work. I need 4 days to go to a mother-daughter bonding overnight camp for Girl Scouts. And the supervisor says, that's fine. We have a discretionary leave policy. Have fun with your daughter. Bring me some Girl Scout cookies when you come back. The next week, I go to our supervisor and I say, I need a few days off to take my father to intensive cancer treatments out of state. It's going to be a really significant battery of treatments, and I need to be there for him. And the supervisor says to me, well, Fran, you're not FMLA eligible. You haven't worked here for at least 12 months. And because of that, I can't give you leave. That supervisor just committed associational discrimination. Cindy got a benefit to go on a leave of absence, a brief one, for a family member with a non-medical issue. I sought a similar leave of absence, roughly the same period of time, to help a family member with a medical issue. Hers was granted, mine was denied. That would be prohibited. So let's talk about serious medical conditions and disabilities under the statutes. Serious medical condition is any illness, injury, impairment, or physical or mental condition that involves an incapacity due to pregnancy, an incapacity due to a chronic condition, a permanent incapacity, an incapacity that requires inpatient care or continuing treatment, or absences from multiple treatments. Disability is a bit broader. It's any disorder or condition, even a cosmetic disfigurement that affects one or more bodily systems, or a mental or psychological disorder like an intellectual disability or an emotional illness that substantially limits. Now, substantially limits is not defined in the statute. It's construed broadly, though. Substantially limits does not mean you're prevented or you're severely limited in performing a major life activity. It just means, as compared to most people in the general population, you're limited in doing this act. And the final element of the ADA definition is the impairment has to substantially limit one or more major life activities. And this isn't a presentation on defining disability under the ADA, but you should know major life activities is broad. It's a broad concept. Caring for yourself, seeing, hearing, breathing, sitting, standing, walking, lifting, bending, speaking, working. It could be any number of things. It even includes the function and operation of bodily systems. So glands and cell reproduction. These are all major life activities. The takeaway from this slide is the concepts are different, But in a lot of cases, they will overlap. And when they do, we need to know how to handle that overlap. And,
So
oh,
let's
go ahead,
talk
Cindy.
about some types of leave under the FMLA and the ADA. So we've all heard of full-time leave, which we know may be taken in one continuous leave period or in two or more separate leave periods. There's reduced work schedule that allows an employee to work less than they're normally scheduled. So it reduces an employee's usual number of working hours per work week, or maybe their number of hours per work day. A reduced leave schedule is a change in the employee's schedule for a period of time, which could be normally from their full-time status to maybe going part-time for a period of time. And then you've probably heard of intermittent leave, which is separate blocks of time, which may be as short as an hour. So maybe they have treatment, they need to leave work to see the doctor, or it may continue for several weeks due to a single qualifying reason.
Thank you, Cindy. So now let's talk about how we approach the leave labyrinth. So when ADA and FMLA come together, what do? Well, number one, we look at each law separately. And then we analyze the employee's request for leave under each law. Do they meet the FMLA eligibility requirements? Do they meet the definition of disability under ADA? Would granting leave under ADA constitute an undue hardship? And then we apply the law or laws that govern the situation. If more than one law applies, if both ADA and FMLA apply, we go with the statute that provides the employee with greater rights at each step of the leave process. If there's one thing you take away from this webinar today, it should be the concept of greater rights. There's the pre-leave process, there's during leave, and there's returning to work from leave. And at each step, the ADA or the FMLA may be more protective. And when that happens, if they both apply, we give the employee the benefit of the law that gives them more protection at that step. So let's do a hypothetical. One way the ADA and FMLA interact is that the ADA can pick up where FMLA leaves off. So in this hypothetical, let's assume the employer is covered by both statutes. They have 50 employees, or at least 50 employees, so they're hitting both buckets. An employee comes to the supervisor and says, I need to be out for 28 weeks because of my medical issue. That employee has worked for us for 6 years and has a regular full-time schedule. So it's pretty clear this employee is FMLA eligible. So they get their 12 weeks as a matter of right. Again, there's no defense or reason to deny FMLA leave. So that covers weeks 1 through 12. At the end of 12, the ADA may pick up where the FMLA left off and grant an additional 16 weeks. Now here, it's not a matter of right. The leave request has to be reasonable, and it can't impose an undue hardship. When I talk to employers about this concept of undue hardship in a situation like this, where the ADA picks off where the FMLA leaves off, I always stress when we're looking at undue hardship, we're not looking at whether 16 weeks of additional leave is an undue hardship. We're looking at, is 28 weeks of leave, almost over half a year, an undue hardship? So you look at the whole leave period, not just the portion covered by ADA. Another practice that I like to encourage and I recommend is undue hardship doesn't matter to the FMLA. It's not a defense. It's only a defense or a reason to deny leave under ADA. But that doesn't mean during the period of FMLA leave, we forget about undue hardship. What we do is we compile evidence of why more leave might be an undue hardship. And the best evidence of that is how the department has been functioning without the employee during the period of FMLA leave. So have supervisors email you things like, are employees, excuse me, are employees working longer and harder? Are employees complaining about having to pick up the slack? Are we missing deadlines? Are we seeing declines in our customer service? Are we seeing customer dissatisfaction in the form of complaints? Is work just not getting done? Are things sitting and holding projects up? Is there a cost? Is there a temp that we brought in? And how are those costs looking like? Document these things in real time during the FMLA period of leave on this chart, so that when it comes time to determine whether we can grant an additional 16 weeks, we know whether or not it will be an undue hardship. So I do like doing that during the FMLA leave. I think it's a good practice, and I think it gives you the best defense, because memories will fade, and supervisors may forget about struggles that they had during the FMLA period. But having them documented and forwarded to you as HR in real time, you'll have a repository of those, and you can determine whether or not continued leave is going to be an undue hardship. So now I'll turn it over to Cindy for a real world example.
Thank you. Yes, so a real world example of an FMLA and ADA overlap. I'm going to read the situation and then get your thoughts. So there was a private school teacher who exhausted FMLA leave after undergoing 3 hip surgeries in the same year. The teacher's doctor submitted medical documentation that the teacher's condition would last 3 to 6 more months. The school denied granting additional leave as an accommodation, stating it could not accommodate a request for an extended and continuing leave of absence with no set end date. How often have we run into that? So with a show of raised hands, I think you can raise your hand. If you think yes, did the school make the right decision? If you think yes, please raise your hand.
Okay, so I'm seeing some hands going up, and the school did make the right decision. This is a real case decided late last year by the First Circuit Court of Appeals. That's a federal court that sits in Boston, but it applies to and governs federal law issues in Maine, New Hampshire, Massachusetts, and Rhode Island. So most of the states our attendees are from today. The court said, this is a teacher. She has to be in the classroom teaching. And it's not reasonable for the employer to grant leave for a period of time, an extended period of time, without a return to work date. The court said it's not indefinite leave. Under the ADA, indefinite leave is not required as a reasonable accommodation. An employee has to provide a return to work date. And it said it wasn't technically indefinite because she was going to come back eventually, but she just didn't know when. They said an employer can't function with that uncertainty, especially when they need someone in the classroom. And relying on substitute teachers was detracting from students' experience. They didn't have continuity in the classroom, and it was costly. And for those reasons, the court said the school did the right thing, and didn't violate the ADA by terminating the teacher's employment. So, the key here is ADA picked up where FMLA left off, but because the leave request wasn't reasonable, open-ended, requiring costly substitute, impacting student learning, because it wasn't reasonable, she didn't have any protection under the ADA. So the second way ADA and FMLA overlap is the ADA can provide a leave benefit when the FMLA doesn't apply. So here we have a situation where an employee needs 28 weeks off again for a medical issue. The employee's hasn't worked for us for at least a year, so FMLA doesn't apply. In the chart, you can see no entitlement to FMLA, but ADA may still be required ADA leave. Again, 28 weeks is a pretty long time. There are no hard and fast guidelines, so I'm not going to say, oh, you can deny this as a matter of law. You can just go out and deny it. It's always going to depend on the facts and the circumstances, like the school that we just talked about. You have to look at how is this leave impacting operations. And if you can come up with those reasons and those explanations, you may have an argument that the leave is unreasonable or an undue hardship.
So here's a hypothetical scenario that will run by you regarding ADA providing leave where the employee is ineligible for FMLA. So in this example, Angela works in a department that must be staffed 24 hours a day. Employees in this department all work shifts longer than 8 hours. Angela has a serious medical condition, requests and submits an FMLA certification from her provider stating that she can't work longer than 8 hours per day. Her employer denies her FMLA request, saying that Angela's needs would be better suited by an ADA accommodation in a form other than leave. So is this permissible? If you think yes, again, we ask you to please raise your hand.
So again, number of hands going up. In this situation, it is permissible because we've said the employee is ineligible for FMLA. So that's pretty clear. But let's put a wrinkle on it. Let's say the employee is eligible for FMLA. Would this be permissible? The employer says, I don't really want to give you FMLA leave. I would rather look at this through the lens of ADA accommodation. Would that be permissible if we change that fact? The answer to that is no. And that comes from an opinion letter from the Department of Labor from early last year. What happened in that case was an employer had a department that had mandatory overtime requirements. A number of employees provided FMLA certifications saying they needed intermittent leave on the days when they had to work mandatory overtime. Because of their medical condition, they just couldn't work the mandatory overtime. The medical certifications all identified the same medical condition, and almost all of them came from the same doctor. The employer wrote to the Department of Labor saying, we want to treat these as an ADA request for an accommodation, not as a request for intermittent leave under the FMLA. The Department of Labor said, you can't do that. If the employee is FMLA eligible, it's up to them whether they take FMLA intermittent leave. And the DOL noted, these employees work a lot. So they're probably going to hit the 1,250 hours requirement every year. And if that's true, their intermittent leave could carry on indefinitely, forever. They will be excused from mandatory overtime for as long as they work for us. The employer obviously didn't want that. That's why the employer wanted to say, I want to look at this through the ADA lens. The employer wanted to say either, I'm denying your request because it's an undue hardship, which, I don't know all the facts of the situation. I just know it's in the opinion letter, but it does sound like it would be an undue hardship where very few people are available to work mandatory overtime, and we need to get this work done. Or the employer wanted to say, look, I can't give you time off, but what I can give you is some other kind of accommodation during your mandatory overtime period. Maybe you could work mandatory overtime if I gave you a couple unpaid breaks during the mandatory overtime period. So the employer clearly wanted to either find someone else who could work this mandatory overtime or bring this employee into work for mandatory overtime with accommodations. DOL says if FMLA applies, the employee is entitled to invoke it. And you can't kind of force them to go the ADA route. Now, if an employee comes to you and says, same situation, and they say, I want an ADA accommodation. I don't want to miss my mandatory overtime. I like mandatory overtime. I make more money that way. Um, so I don't want intermittent leave. Is there anything you can do for me? Well, then you can look into it and see if there's an accommodation that you could give the employee that would allow them to work and perform the essential functions of their job. But if you go that route, document, document, document. You need to make it clear that this was the employee's choice. The employee could have had intermittent leave, but they wanted to be paid their mandatory overtime. So the employee made the choice to forego FMLA leave and go the ADA route. So important to document. So what the employer wanted to do here was basically deprive somebody of FMLA rights, which can't do. There is something else they could have done, which they didn't think of, and that is test the veracity of the medical provider's certification. If you recall, I said a lot of employees in the department had the same condition, the same limitation, and it all came from the same medical provider. That would make me highly suspect as an employer. What I would do is I would say, okay, we're going to get a second medical opinion here, which we can do under the FMLA. And if that medical opinion is different from your provider's medical opinion, then we go to a tiebreaker, a third medical opinion, that the employer and the employee get together, they pick a doctor, and that doctor says definitively, with binding authority, whether or not the employee is entitled to intermittent leave. They have the condition and the limitation, they say. I would have done that because it seemed highly suspect, but that's not what they did here. Just something to keep in your repertoire, because what they wanted to do, you very clearly cannot do. So let's move on to section 2, recognizing leave requests. The concept of how to recognize a leave request under ADA and FMLA is very similar. Magic words are not required. An employee doesn't have to say FMLA or ADA or serious health condition or disability or reasonable accommodation. And they don't have to put it in writing. An oral statement to a supervisor is enough to request FMLA leave, or at least put the employer on notice the employee needs FMLA leave, or to start the interactive process in looking for an accommodation. But it does have to be specific under both laws. Under the FMLA, the employee needs to indicate that the employee needs FMLA leave based on their own serious health condition or a covered family member's serious health condition. Again, there are other FMLA leaves we're not talking about, but those two are what we're focusing on. And the employee has to let the employer know the anticipated duration of the leave. The employee doesn't have to have all the information available to them when they request leave, but they have to provide whatever they do have available. Under ADA, the employee's request has to indicate that they may have a disability. Doesn't have to establish that they have a disability, and that they may need a change to the work environment or the way work is done because of limitations imposed by that disability. Again, it's may. The interactive process is when we find out whether the employee in fact has a disability and in fact needs an accommodation. At this stage, they're just putting us on notice that they might be limited and they might need something. Under the FMLA, if the employee's statement is unclear, the employer has a duty to inquire further to see if FMLA leave is being sought or may be appropriate.
So here's a real world leave request example to get your thoughts on again. So in this case, Monica, who has poor attendance, texts her supervisor the following. Currently in the emergency room, my mother has been taken to the ER via ambulance. Can't come in today. So Monica's supervisor simply notes in the attendance log, sick mom. 4 days later, Monica was terminated. Did Monica put the employer on notice that she needed an FMLA leave? Again, if you think yes, please raise your hands.
Okay, so some answers are coming in. The answer here is maybe. Maybe Monica did. This is from a real case. And what the court said is the employee had given the employer enough information to conclude that the FMLA may be in play. Therefore, the employer had a duty to inquire further whether FMLA leave was necessary. The court went on to say the employer didn't make that inquiry. Instead, a few days later, it terminated the employee's employment. That raised an inference that the employer took action so as to interfere with the employee's FMLA rights. And what that means is this case went to trial. In employment cases, we often ask judges to throw the case up before trial. We go through a process called discovery, where we collect documents, we exchange documents with the other side, we conduct depositions, so we ask the plaintiff questions under oath, and they ask our supervisors and HR professionals similar questions under oath. And at the end of all that, we say, there's no dispute about these key facts. And these key facts establish that there was no legal violation. So throw the case out. Employers do that all the time. And it can be successful. That's not what happened here. So this case went to a jury trial. And you generally want to avoid jury trials. It's not great to be an employer before a jury. People, especially in the Northeast, the juries tend to lean in the employees' favor. Juries can be unpredictable. And more than anything else, jury trials are expensive. They cost a lot of money and they take a lot of time. So what if we change this? What do we think about, did Monica put the employer on notice that she needed an ADA accommodation? I think if we change it like that, the answer is no, because remember, the ADA does not require us to accommodate an employee's family member's medical condition. But always remember associational discrimination, because if something similar happened, Fran texts the supervisor and says, school meeting for his son. And then I'm kept on. And then Monica says, in the hospital with my sick mom, and she gets fired. That could be potentially associational discrimination, depending on whether Monica's mom's sickness rose to the level of a disability. The key takeaway here, train managers to recognize leave requests. No matter what your policy says about how to request an accommodation or FMLA leave, the reality is managers are going to get the first request the majority of the time. And as soon as they get that request, their knowledge is imputed to the employer. A manager's knowledge is the employer's knowledge. So they have to act appropriately when they receive that request. So here's a question that I get a lot, and the courts are in disagreement over it, but does a request for FMLA leave trigger the ADA interactive process? You'll see on the slide, the Third Circuit, that's a court in New Jersey. It covers Pennsylvania, New Jersey, and Delaware. Relatively progressive court says an FMLA leave request may qualify under certain circumstances. And what the court meant there is when somebody asks for leave because of their own condition, it may qualify as a request for a reasonable accommodation under the ADA. The Fifth Circuit, a relatively conservative court, takes the opposite view. It says a request for FMLA leave does not automatically trigger the interactive process. Why? The statutes have different purposes. An employee who says, I need FMLA leave, is saying, I cannot work. An employee who says, I need an accommodation under ADA is saying, I can work with a little bit of help. So these different purposes lead to a different result here. What does the EEOC say? The EEOC says if an employee requests time off for a reason related to a disability or possibly related to a disability, the employer should consider it as a request for ADA reasonable accommodations as well as FMLA leave. I think in all practical terms, that's right. That's what I typically advise. Consider the request under both statutes. Remember the leave labyrinth slide. Look at both laws side by side. Which one applies? Or do they both apply? The ADA also, the EEOC rather, goes on to say, if the employee says, I just want to invoke my rights under FMLA, I don't really want to invoke anything under ADA, the employer shouldn't make additional inquiries related to ADA coverage. That's the concept of greater rights. FMLA certifications are a lot narrower than ADA medical documentation can be. FMLA is just looking at duration of the condition and the existence of the condition. ADA is looking at, is there a disability? What are the limitations? And how, if at all, can we accommodate them? It's a lot broader. So I actually disagree with the EEOC here. I take a more employee-friendly view, and I think it's a better practical approach. If an employee comes to you and they request leave for a medical issue and they're FMLA eligible, just go the FMLA route at this stage. Don't make them say, I'm not invoking my ADA rights. I've never seen that done. It's not practical. It just doesn't really make sense. I would say FMLA eligible, go FMLA. If not, then go ADA. So now we're going to talk about how to assess and respond to leave requests. So here you'll see the FMLA. An employer has 5 business days from an employee's request for a leave or otherwise learning the employee may need leave to provide a notice of eligibility and a notice of rights and responsibilities. The notice of eligibility can be provided orally. I really don't see a benefit to doing that because there could always be a dispute whether or not the employer provided it. Provide it in writing. And both of these notices are available on the Department of Labor's website. Now, once the employer provides those notices and requires the employee to return a medical certification, the employee has 15 calendar days to get that certification in. You can see these requirements are very consistent with the FMLA's general approach. The FMLA is rigid. You get 12 weeks, no defenses, no exceptions. Then when it comes time to review your documentation, you have 5 days to get it out. And then you have 15 days to get it back. It's very rigid and formulaic. The ADA, which is on the other side of the slide, is very different. There are no prescribed deadlines. It's all about what's reasonable, what is good faith. So during the interactive process, don't unreasonably delay. When you know an employee may need a change to the work environment or the way work is done because of a medical issue, start those conversations promptly. If you need to go and talk with the manager or a supervisor to figure out the employee's job functions, let the employee know that we have to meet internally and we'll get back to you. Keep them in the loop as you're going through your discussions internally. Move quickly. If they have something, if they need something and you have it readily available, I would say give it to them. There's a famous case where the Department of Labor, of all employers, the Department of Labor had an employee who needed a high definition monitor for a seeing impairment. And they went through a process of reviewing medical documentation and going back and forth with the employee about what he needed and why, and talking to his doctors and researching monitors. Come to find out, they eventually approve it 9 months later. When they do, a custodian unlocks a closet across from the employee's office and pulls out a dusty monitor that had been there the entire time. Don't do that. That's how you get in trouble under the ADA. So I mentioned you can ask, oh, one thing I should mention too, when it comes to ADA medical documentation, I typically recommend giving employees 15 calendar days to return it. Um, I'm not aware of any cases or EEOC guidance saying how long is reasonable, but I do think that 15 calendar days, which is the FMLA's deadline, I think that's reasonable. It's over 2 weeks. It gives an employee sufficient time to get the medical documentation in. If they have a reason why that isn't sufficient, they couldn't get to the doctor because of their condition, for instance, give them more. But I think 15 calendar days in the run of cases makes a lot of sense. So now let's talk about permissible medical inquiries. We alluded to this a little before, but FMLA, you're limited in what you can ask. Leave duration and whether there's a serious health condition on the employee's part or a family member's part. ADA, a lot broader. You can ask about the disability, limitations, and potential accommodations. The standard there is it must be job related and consistent with business necessity. So that's a key point. I've seen a lot of employers have ADA medical certification forms, and they use them routinely. I think those are good starting points, but they have to be adapted for the specific situation. So if you have an employee who's in a wheelchair, you don't need their doctor to certify that the employee can't climb stairs. So questions about the existence of a disability shouldn't really be asked. You don't need them. Same thing, an employee who's blind. You don't need a doctor to certify that they can't read a computer screen. You don't need that information. Take it out. What I recommend is you should have kind of a repository of questions. These focus on the existence of a disability. These focus on the limitations a disability creates. These focus on the ways in which we may be able to accommodate them, and draw from that bank whenever you need to send out an ADA form. I think it's important to note, while the DOL has issued several FMLA certification documents, EEOC has been asked repeatedly to create reasonable accommodation paperwork. EEOC has denied every request to do so. And the reason is you just can't do it. It's too fact specific. It's not as cut and dry as FMLA. Look at the concepts: job related, business necessity, reasonable accommodation. These are going to depend on the employee's job functions, the nature of the disability, the nature of the limitations, and the changes the employee's requesting. Very, very, very fact specific. There are rules about what employers can ask about under both statutes. EEOC has fortunately said, common sense approach, an employer doesn't violate the ADA's restriction on medical inquiries by asking for FMLA paperwork. So if you ask for FMLA paperwork, you don't have to worry about the ADA's restrictions.
So with medical documentation, as you know, we must maintain confidentiality. So an employer may keep a single confidential medical file that's separate from the employee's personnel file, containing both ADA and FMLA medical information, if the employer follows ADA confidentiality standards. So as you know, employer must restrict manager and supervisor access. That's the reason why we separate it from their, performance reviews and other information a supervisor might ask for. Employers may give supervisors and managers information concerning an employee's work restrictions and accommodations, or even giving information about when the employee is expected to come back to work. So for that, it is fine to keep the ADA and FMLA paperwork together, but just needs to be separate from the ordinary employee file.
That's right. Thank you, Cindy. So now we'll turn to section 4, administering FMLA and ADA leave. A key question when it comes to leave administration is what happens to benefits, health benefits specifically. FMLA, very specific. An employer has to maintain the employee's existing coverage under a group health plan during FMLA leave as though the employee had been continuously employed during the entire leave period. During that time, the employee has to pay their share of premiums. And a failure to maintain benefits as though the employee had been continuously employed violates the FMLA. The obligation to continue benefits under FMLA ends when 3 things happen. Number 1, the employee is terminated for a reason obviously unrelated to the FMLA leave. So the position is eliminated as part of a reduction in force. Number 2, an employee informs the employer of their intent not to return from leave. This is true even if the employee says it before the leave starts. The thing to note here is it has to be unequivocal. The employee has to say, I'm not coming back. Kind of no exceptions, no wiggle room, no vague language, an unequivocal intent not to come back to work. Number 3, if an employee doesn't come back from the 12-week period of leave, or just stays out after the FMLA entitlement is exhausted, the employer doesn't have to continue health premiums. Now, at that period, the employee may switch over to ADA leave. So what does ADA say? ADA says you have to continue an employee's health coverage if you do so for employees on similar leave statuses. It's the concept of discrimination. If people are out of work for non-disability related reasons and they get to keep their benefits, you have to let people who are out of work for disability related reasons keep their benefits. Got to treat them the same. So another administration point is what happens, and this happens a lot, what happens if we learn about an employee's malfeasance or bad conduct while they're out on leave? Or what if the employee knew we were investigating something they had done and they take leave during the investigation? I mean, are our hands tied? Is this employee insulated from discipline just because they requested leave? The answer is no. If an employee would have been disciplined or discharged regardless of the leave, then the employee can be discharged or disciplined before, during, or after the leave. The key is you want to make sure that you have solid documentation of the reasons for the discipline or termination. So do things like require regular performance evaluations, require managers to document their performance concerns and communications with employees about performance concerns. If an employee engaged in misconduct, investigate promptly. All of these, following these practices will help you as the employer provide a solid reason for your adverse action against an employee and show it has nothing to do with their leave. Obviously, you want to avoid connecting discipline in any way to a covered leave. Another thing to note, we talked about manager training when it comes to recognizing requests. Manager training is important here too. Managers need to be trained on the need to address performance misconduct issues promptly. A lot of managers will say, well, I didn't address that issue because I know that employee has a medical condition and I didn't want to seem like I was coming down hard on that employee. There are cases that say that in and of itself is discrimination. Why? Because if the employee wasn't disabled, you would have coached them. You may have put them on a PIP. You would have given them an opportunity to improve. But what happens in almost every case, ignoring a performance deficiency is not going to help it get better. And it'll eventually come to a head and come to a point where termination is the only option. And when that happens, the employee will say, I didn't have an opportunity to improve, unlike my non-disabled colleagues. and that can be a viable discrimination claim. So train your managers on properly managing performance and conduct expectations.
So going over manager rights during a leave, you may get asked a lot when you have someone on leave, when are they coming back, or even details about the leave. So managers are entitled to periodic reports regarding an employee's status and duration of the leave and their intent to return to work. Generally, managers should leave these conversations to human resources and not have these conversations themselves. If a manager has a business need to speak with an employee, for example, so that the manager can arrange for appropriate coverage of work that an employee has been performing before they went out on the leave, these types of conversations are appropriate. But now I'm going to ask Fran this question. So why might it be better to have HR handle these conversations?
So HR is accustomed to handling these types of conversations. HR professionals generally know what to say and what not to say. Managers might not know. And a statement made during one of these phone calls could be used to show the manager was antagonistic toward leave, or it could support an argument that the manager intended to chill an employee's exercise of leave rights on future occasions. The employee may also volunteer medical information, which it's better for the manager not to know. So there are a lot of reasons why HR should do these types of conversations. General idea, keep managers out of conversations with employees to the extent possible while they're on leave. All right, returning to work. This is our last section. Reinstatement. FMLA provides that employee is entitled to return to their same position or an equivalent position when they return from leave. When we look at whether a position is equivalent, we look at the pay, benefits, working conditions, privileges, and status. Under ADA, an employer must hold the employee's actual job open unless that would be an undue hardship. Now, under FMLA, there is an exception to reinstatement called the key employee exception. It's often confused to be an exception to the FMLA altogether. It's not. Key employees have a right to leave. They just don't have a right to reinstatement. This is not a very common exception. It is the top 10% most highly compensated employees at a location. They have to be salaried. And their absence would have to cause serious, grievous economic harm to the employer. The ADA doesn't have that type of exception, but again, it does have undue hardship. So when they overlap, basically, you have to show why you can't return the employee to their actual position. Why would that be an undue hardship? Why do they get an equivalent position? You have to show that to comply with ADA. So you have to manage, you have to juggle both here because they're both providing substantive rights.
So I'm going to go through this one quickly because I know we only have a few minutes, but this is a hypothetical return to work scenario to run by you. So Joan, a project manager, reviewed government regulations and contract servicing agreements. The position also allowed her to apply legal knowledge she acquired during her studies in law school. For a few months, Joan took leave for depression and anxiety. Upon her return, her employment looked something like this. She was placed into a new position, which maintained the same pay, benefits, work hours, and locations. However, she performed more clerical duties. She reported to a former peer. The new position did not require the same use of her legal expertise, and her opportunities for career advancement were dismissed in the new role. So, Fran, do you think Joan was placed in an equivalent position?
I don't think so. Her duties were less prestigious. She's not going to be as desirable in terms of being promoted or getting a job elsewhere. She's reporting to a former peer. That is a step down in her mind. She's not using her knowledge that she acquired. I mean, it's really the status of this job is really a rung lower than her prior job. So for that reason, I don't think it's a equivalent position. So in our last minute, I want to flag an enforcement issue the EEOC is very, very keen on, and that is 100% healed policies. A 100% healed policy says you can't return to work unless you're fit for duty and 100% cleared. That's fine under the FMLA because the FMLA doesn't really care about what happens after you exhaust your entitlement or your leave period ends, but it's not fine under ADA because you may have a right to leave as an accommodation after your FMLA leave ends, or you have a right to return to work with an accommodation. So you're not 100% healed, but you could do your job with a little bit of help. For that reason, the EEOC has taken a very aggressive position on these. If you provide your handbook or your policy to the EEOC in a charge, and it's not even about this issue, they may start an investigation into it separately because they really don't like seeing these policies.